that question to my non-trained, that it is covered or not, take instruction. He said, subsequently, it is not covered. That is why Ratsu wanted to argue matters. You know, say, take that I prepared. There's one of the REIT application which has been transferred. It has got a copy of this. This one is code. I am giving you a copy. It has said it a code. Code copy. Sure. 29/12/1993. Subject to my non-friend kindly permit me himself. Basic then all right. 19/12/93, National Council of Teacher Education Act 1993 came into force. Section 29 of the Act provides for binding effect of the direction on the question of policy of the central government on the NCT. The 9/8/2017, the Right to Children to Free and Compulsory Education Amendment Act 2017 came into force, and the following proviso was inserted to Section 23. Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right amendment. Right, sir, right. 2007. Then 22/9/2007, it is very important, which has been given much emphasized by the Supreme Court. The NCT, in view of the direction of the Human Resource Department under Section 29 of the NCT Act 1993, and after considering the recommendation of the expert committee, the chairman, NCT, in exercise of the power under clause 12 of the NCT Recognition Norms and Procedure Regulation 2014, was pleased to grant relaxation and the direction of ODL program for in-service on-trained teachers who reduce it to 18 months instead of 2 years. That's a market through ODL mode, and the requirement of 6-month internship was earlier it was 2 years, 18 months program. That is Annexure 2. Before I take your shift to the other debates, let's look to that Annexure 2. That is the crux of the matters. 2017 at page 224. That is issued by the National Council of.
What has happened actually? Give me the brief.
Sir, what has happened? These petitioners, they are the in-service candidates as of 2017, and they have completed 18 months of training as training from 17 to 2019. Now the whole question for consideration is the NCT order, that circular, which was issued by the NCT in 2017 in terms of Section 29 consultation with central government. So whether they will be covered by that or not, that is the only question.
According to you, they are covered.
They are squarely covered by the judgment of the Supreme Court also, because various
Covered for what purpose?
Covered for the purpose of getting selection and appointment. Selection appointment. Just I'm taking to worship straightway to this circular. Then I'll take your worship to the judgment. That is, I think, for your worships, need not go to other things. Sir, the also look to page 24. Page 24.
Recognition order.
Yes, sir. This is National Council of Teacher Education. Recognition order dated also look to 22 September 2017. By 22 September 2017. I'm just reading that. Sorry, sir.
September 2017.
Yes, sir. Page 24, Annexure 2.
Recognition order means a recognition issued to any particular individual.
No.
It's policy matter.
Policy matter. You also see to be published in the official gazette, that has been published. Whereas the matter of recognition of the project proposal of National Institute of Open Schooling, NIOS, Noida, or DALED, ODL, that is called ODL, program, through SWAM proportion and SWAM training of in-service on-trained teacher was considered by NRC and NRC oversight as follows. And whereas relevant, just next line. And whereas the NCT has received direction under Section 29 of the NCT Act from the Minister of Human Resource Development Department, that is once. Relevant is the last part one paragraph. And whereas in view of the mentioned direction of the Minister of Human Resource Development under Section 29 of the NCT Act, and after considering the recommendation of the expert committee, chairperson NCT in exercise of its power under clause 12 of the NCT recognition norms and procedure regulation 2014 granted relaxation to guide NCT headquarters letter NCT dated 21/9/2017 and 22/9/2017 to the following provision in the NCT regulation 2014 for ensuring that the directives of the MHRD for implementing the amendment of the RT Act 2009 are duly fulfilled. One. The amendment which you just read, the 2017 amendment. Any provision related to online submission of the application of NCT application portal. 2. Any provision related to duration of the program so as to reduce it to 18 months instead of 2 years, and the requirement of 6 months internship to be subsumed within the duration of 18 months. The next page
Means what?
Yes, page 25.
No. What is meant by 2?
Yes, sir. Then for EQP, it was the duration program, it will be reduced to 18 months instead of 2 years. You can also look to that.
That would include internship also.
Yes. That is. That.
There is no requirement of 6 months internship.
That is
how 18 months is brought down.
Yes.
Otherwise, it will be defeated.
Right, sir. Sir, kindly look to page 25. Why this was made, just page 25. Let's look to page 25. Whereas, after having considered all the above facts and figures, the NRC considered the case in its 275 meeting, the part 3, decided that recognition be granted to National Institute of Open Schooling.
Now to item number 1.
Yes, the duration, yes, that's correct.
Duration of the
Duration
same program
shall be 18 months instead of 2 years.
including 6 months internship.
As you also right. And this has been done because of that 2017 amendment. You also look
RTE amendment.
Yes, RT amendment. They said that grace period also look to that 2 years.
That explain that gave 3 years.
That nice. Say that
31 to 4 years.
4 years.
4 years.
Yes.
4 years.
Provided further that every teacher, this came into force on 9th August 2017, provided further that every teacher appointed or in position, we are appointed earlier, as on the 31st March 2015, who does not possess the minimum qualification as laid down under subsection 1, shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right of children to free and compulsory education amendment.
That is August 2017.
The 4 years will end on 31st March 2019.
19. Because the cutoff date is 31st March 15. So
Within 4 years.
Within 4 years.
31 March 2019.
Right. Now, you also straightway, according to me, also come to the judgment. That judgment I have enclosed.
No, what is their version? Their version is.
Sir, I'm coming. They are saying, they are referring to a review order. I'll just pick just 2-3 minutes. Kindly come to that judgment. That will solve the entire purpose. That is for your access to take a decision in terms of that judgment. Page 80. Page 80.
In JVC.
Yes, sir. Yes, sir. Then you also kindly come to yes. You also come to page, what is the relevant portion? 4.6 to 4.10, then I'll take your also to relevant portion. In view of the provision, 84, running page 84. Yes, sir. Yes, yes, sir. In view of the provision, second provision to subsection 2 of section 23 of the RT Act, MHRD issued a letter on 3rd August 2017 to all the secretaries of the state and union territory directing that all the teachers in the government school must possess minimum qualification.
As per IIT Act.
Sir. Then, sir, kindly come to port 7. NCT issued a recognition order 22 September 2017, which just now I placed people on it, thereby conducting DLED program through ODL mode by NIOC OS through the sham portion of MRC for in-service untrained teacher at elementary level working in government aided and unaided private schools The said recognition order also reduced duration of diploma from 2 years to 18 months. Then, sir, para 4.10, it appears that High Court of Patna has passed a judgment on 21st August, January 2020,
Holding that.
in the case of Sanjay Swansong, holding that the Director of Primary Education NCT has illegally issued a direction that the person who had obtained DLT course for 18 months by NIOS was not eligible for appointment on the post of teacher in primary. It held that said direction of the Director of Primary Education was issued on misrepresentation and misreading of the
Tripura High Court also took the same.
Sir, then paragraph 23. Kindly come to paragraph 23. That is at page 89. Page 89.
Paragraph
23.
thus clear.
Sir, it is thus clear that all such teachers working in either government, government aided, unaided private schools were required to acquire the minimum qualification by 31st March 2019, or they would face dismissal from service. It appears that it was decided by the central government to provide a window.
Dismissal from service.
Yes.
Removal from service.
Removal. The difference between removal and dismissal. That's right, sir. It appears that it was decided by the central government to provide a window for all such teachers in service and that 18 months. A perusal of the said communication would reveal that various directions were issued so that lakhs of teachers who were untrained get the requisite qualification prior to 1st April 2019. The communication addressed by the Director of Elementary Education Uttarakhand dated 8th September 2017 to the Education Officer and District Education Officer would further clarify this position. Then the page 24, that 22nd September 2017, I have already placed before Lordship, that has been quoted.
Yeah.
Yes. Then, sir, kindly come to para 25. Next page, page 90, para 25. It is thus clear that the said recognition order was issued so that the directives of MHRD for implementing the 2017 Amendment Act duly fulfilled. It appears that since the time gap between the direction issued by the MHRD and 31st March 2019 was only about 18 months, the period of course was reduced from 2 years to 18 months. This position would be clarified from the said recognition order itself, which reads thus, any provision that you have already read that. And para 28. Yeah. It can thus clearly be seen that as on 6th September 2019, it is also the view of the NCT that minimum qualification for appointment of teachers for class 1 to class 8 is a 2 years diploma in elementary education. It further clarifies that NCT recognition order dated 22nd September 2017 was only for those untrained in service teacher, that's the market, in government aided, unaided private schools who were appointed on or before 10th August 2017. It further clarified that for fresh appointment of teachers for primary and upper primary level, NCT notification 23rd August 2010 and 29 July 2011 need to be strictly adhered to. It is further to be noted that whereas notification is also skip over. Then para 29. It is thus clear that the entire scheme has for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to 1st April 2019, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that the High Court has erred in holding that 18 months diploma conducted by NIOC through ODL mode is equivalent to 2 years diploma as provided in notification of NC dated 23 August 2010 and 29th July 2000. That for the fresh candidate, that the question is whether equivalent or not. But so far the one window which was
This is for inside.
yes, sir. That is exactly. That is only case, sir. The para 31, sir. We find that High Court of Patna has totally erred in not giving effect to the stand of the NCT. As a matter of fact, we fail to understand as to why NCT did not challenge the said order when its specific standard that the said 18-month course was only for in-service candidates and not applicable to fresh ones.
For them 2 years only.
Yes, sir. Then, sir, kindly come to para 35 at page 93. Para 35, in para 35, page 93. As already discussed here in above, NCT recognition order dated 22nd September 2017 was issued so as to give effect to the directive of MHRD dated 8 September 2017 so as to provide a one-time window to the teacher who were already working and who in terms of 2017 Amendment Act required to acquire the minimum qualification prior to 1st April 2019. The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention to 2012 service rules and the advertisement. Then let us kindly come to para 41, which is the concluding paragraph. Page 95, para 41. In view of what has been held by this court herein above, we find that High Court erred in holding that 18-month diploma conducted by NIOS through ODL mode is equivalent to 2 years regular diploma, particularly so when there was no material placed on record to even remotely hold that such a qualification was recommended by expert body NCT. On the contrary, this is important. The communication dated 6 September 2019 of NCT, the directive of MHRD, so also the recognition order dated 22nd September 2017 clearly go to show that 18-month diploma was provided as a one-time window to the in-service teacher to acquire the minimum qualification between the 2017 Amendment Act and the outer limit of 1st April 2019.
In other words, this reduction from 2 years to 18 months, 1.5 years, is only for those in-service candidates who were there as on August 2015.
The 10-8.
Because 4 years from that day.
Right, sir.
Okay. So the concession given to in-service candidates is a one-time measure.
One time, yes.
Okay, it's a concession.
That's it.
Perhaps they did not want lakhs of people.
Relaxation in terms of section 29. Yes.
That up to that I have understood.
Sir, that is
It's not applicable to fresh candidates.
No, not at all. That is
Up to this I have understood.
Yes, sir.
Now what is the grievance?
Sir, page 96. Then just concluding that judgment. Page 96 and 3 lines in paragraph 42.
What's the impugned judgments of Uttarakhand?
As already known, that paragraph 42 as already discussed here in above, recognition order dated 22nd September 2007. Para 42 at page 96, just above para 43. As already discussed. Second line. As already discussed here in above, recognition order dated 22nd September 2017 only provides a window for in-service teachers to complete their course prior to 1st April 2009. That's what you lordship said. Now, you lordship look to the batch of applications were filed before lordships. In fact, I'm giving that copy to my rejoinder.
No, why are you here? For the course.
Yes, what they have done, yes, page 42. Page 42.
Notification.
Yes, sir. Page 40 was
This notification is issued by whom?
issued by the Odisha
State government.
State government. And if you also will come to page 44, that is part of that one. Page 44. This is the controversy. This is on 16 March 2024, para 5. Candidates, let's get it.
Apply qualification of
18 month DLE course from September 7 to 19 through ODL form, NIOS will not
be effective.
This is the controversy. Rejection order also see that is at page 14. 11 pages page.
So what it says? Candidates?
Candidate applied with qualification of 18-month DLED course from 2017 to 2019 through ODL from NIOS will not be affected.
Why that situation arises?
Because they say the judgment of the Supreme Court was misinterpreted as if
Questioning. This is for notification is for what? Fresh appointment. Fresh appointment.
This was they are selected. Petitions were selected. They are directed to be present for document verification. But during document verification,
They issued this notification.
Yes, that is a page 44.
Your contention is it was counter to the judgment of
Of the Supreme Court. Right. And
I know what happened in review
just like so show you. The review application was made by the
by the state.
not by the by some candidates
of other states.
some other states. So look at page 97. Page 97. At page 98. Where is this?
1 second. That notification is why that notification came to be issued by the state? State programming authority.
Because the Supreme Court judgment was pronounced on 28/11/23.
28/11.
And the advertisement was issued on 10/9/23.
But you were all in-service candidates.
Yes, sir.
Where is the question of ongoing?
Ajit, they interpreted these candidates because they have acquired these 18 months, even if they are in service, but they are treated as a press one. They said that only which is not applicable. If you also look to page 19, in fact, what has happened, some cases which are transferred, about I saw that I enforced that document. 19 candidates, they are also uploaded this other code to self prayer, just like this, very same advertisement. That was somehow in other cases which are pending before the Supreme Court, that was called for, fine. And that was disposed of, directing that to give appointment to them. That has been also listed. That is also directed, that has come.
No appointment orders are not issued to you people.
No, because they have also passed interim order keeping reserve posts. Because they have been selected, but because of this reason, only the rejection order is at the place. Next 14 pages.
What is meant by in-service candidate?
That has been also said. In-service candidate means as on-time teacher, they have been appointed in a government or private school.
You are already appointed.
Yes, sir.
You are in.
I also have introduced those requests.
One second. I want to get clarity. The law I have understood now, subject to what other side will say. Now you are already in service.
In service, sir, private school, sir.
Private school. You wanted to come to government service.
Yes, sir. This in fact, in the dates that I have given, that advertisement was made for appointment of junior teachers in different various schools, and in that pursuant that we applied, and in fact they entertained our application, but subsequently they said that your application cannot be entertained because you have acquired this 18 months.
That MHRD circular intentionally to protect the in-service candidates wherever they were employed. From there they will not be removed. Those Supreme Court uses the word dismissal, may not be dismissal at all, because it is dismissal, it is removal simplicity, because you do not have requisite qualification. Okay. But for fresh appointment, this should be treated. Where is the observation of the Supreme Court?
That is that paragraph 43.
It is only saving the employment which you have already gained. But if you leave the employment portal here and want to go to some other portal, then the 2 years is required.
That's right. That 2 years is required for the place candidates, for the placers. That is what the Supreme Court has said.
Therefore, I ask you, what is meant by in-service candidates? The object is not to give employment to you. The object is that you should not lose the employment which you are already in. The object of August 2017 amendment is RTN. It required a particular qualification. Those who do not have, that they could have done this within 4 years. Those who do not have, for them, they ran the risk of removal. They ran the risk of removal. Therefore, the MHRD issued that particular directive. In terms of that, NCTE acted under Section 29 and made the particular provision. The object of the provision is to protect you from removal in the employment in which you are already there. The object, see, I am on Heron's rule. In Heron's rule, House of Lords said, perhaps you may be aware of the facts, where the law required fencing off the vessels which carried the sheep in the Irish Sea. The object of the law was to prevent the spreading of disease from one herd of sheep to other, going in other sheep. Then, because of the tidal action in the Irish Sea, perhaps you might have seen Irish Sea is not that smooth, the sheep were washed away. And action was brought by the cargo owner. Had you complied with this rule, our sheep would have been saved. Therefore, I should be given the damages. Law required that. House of Lords rejected it on the ground that the object of the law was not against your sheep being washed away by the tidal action, but to prevent the spread of the disease. If that rule is kept in vain, how are you going to derive milk from this judgment?
Let's look to the review judgment. Review judgment, paragraph 3 probably clarify it answers.
26 of the notification.
Which is that review judgment?
That is 19.
Page 18.
Page 90.
What is the review?
There are some, the grievance sought to be, may I place it? The grievance sought to be raised on behalf of the review petitioner and some of the applicants before this court is that though they were in employment and covered by the recognition order dated 22/9/2000, they believe that the judgment and order dated 28/1/2000 would come in their way if they want to make better their prospects by applying either in other institution or for promotional recognition. I just got it. Then they say that we have already clarified, so it doesn't require any review. But paragraph 3, however, to have.
Kindly read paragraph 2 again.
We have already.
Read once again, paragraph 1.
The grievance sought to be raised on behalf of the review petitioner and some of the applicants before this court is that though they were in employment and covered by the recognition order dated 22/9/2017, they believe that the judgment and order of this court dated 28/1/2011. That is the judgment placed by my one friend before your lordship would come in their way if they want to make better their prospects by applying either in other institutions or for promotional avenue. Then there are paragraph 3.
We have already clarified.
Clarified in the judgment under the review that the one-time scheme was provided solely to
Safeguard the interest of
those teachers who are employed as on 10-8. We are therefore not inclined to entertain the present review exception as well as miscellaneous application.
Yeah.
Then paragraph 3 is important. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10-8-2017 and who would have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions. As a lordship got into. Or for promotional revenue. So we applied
as good as 2 years.
Yes.
As good as 2 years.
Yes. Then my friend was stating he left halfway along. Some of the petition.
Yes, needless to say that the date of pronouncement of the
Clarification will be effective from the date of pronouncement of the judgment under from the date of judgment.
So my friend
Also, as even when you leave that employment in a private school and stake your claim for employment in public school, even then you should be held to be qualified.
Then another feature is that some persons similarly placed like that of the petitioner also approached this Honorable High Court like us. Their cases were transferred to the Apex Court.
They were returned to the Apex Court.
Apex Court directed that since they have 18 months and they are eligible and they are been selected, so give them appointment directly. That is,
we will also look to page 28 of the result. I'm giving that copies.
Because where are those judgments which you say?
I say that I have enclosed the result in my case. Page 28. Annexure 21.
Yeah.
We will also look to page 28 of that agenda, Annexure 21. Order of the Honorable Supreme Court. Let's get it. Let's look to DPC number 1052 and 1404 of 25. Let's get it. The middle, para 3. Hence, the transfer applications are disposed of as withdrawn. Then let's skip over to next page. The sole ground, para 3, the sole ground on which we are denied appointment.
Yes, I see that. Did not possess the diploma.
Yes. Then that goes the matter, the transfer petitioner allowed, the respondent state and directed to issue appointment to the petitioner within a period of 3 months. Then you also look to the page 31. Remember, the case to that.
Okay.
This 1052. People also
That is also fresh appointment only.
Sir, the same advertisement, same.
Very same advertisement.
Yes, sir. Sir, also look to that. I given the copy of the writ application. That is on page 37. Page 37. This is the writ application which has been transferred. And you also have called for that repeats of file also.
the last case in the
The prayer was the same, exactly the same prayer. WPC also kindly look to that file is there. WPC 138 of 2025.
Anyway, and you say that the very same advertisement.
Same advertisement, same prayer.
The Apex Court directed to grant
Give an appointment.
appointment.
Actually, this whole purpose that was it to you.
But they have been given appointment also.
That I know, sir. Otherwise, the process.
Any other point, brother? You want to say anything? You want to add? Don't repeat anything. I have nothing to say.
I was relying upon the circular. But circular, I was pointing at page 26 of the circular, annex to 2 manner.
No, that is considered very Apex Court.
That it is clearly been mentioned that appointment should be on or before 10th August 2017.
Yes.
So the graduates who are in service before to 10th August 2017. So that has to be checked with all the repetitions whether they were in appointment while applying for the force on or before 10th August 2017.
Yes,
That is rejoinder page 25. Given the certificate.
appointment order.
You are Union of India.
There is no dispute regarding that.
On that date of appointment, there is no dispute. All you are appointed
Yes,
before that cut-off date.
Yes.
Before cut-off date. That is 10/8/2015. 10/8/17.
That resolution, sir.
That amendment.
Yes, sir. They told us on 31st March 2015. From that date, within a period of 4 years, that is 31 March 2019, all the candidates have to
Fall
fulfill
within that particular.
For 41,
Because the notification came in 2017 and the 1st April 2019 was the cut-off date. There was no period for that 2 years. That is why
Your stand is those who are
Appointed on or before 10th August 2017, they may be considered.
that is
They qualify for the
there is no dispute. There is no dispute.
No, you are how particular thing. I do not know. But it qualifies for what?
The candidates who were appointed on or before 10th August 2017, they come under the purview of the order of the Honorable Chief, come under the purview of the circular of the government.
Exactly.
NCT circular.
No, you are confusing me. Do you support the case of the arguments of these people or oppose the argument of these people?
And I support to that extent that the appointment should
That we have
that part only.
So you partner with those arguments. You agree with these arguments, their arguments. But subject to they being appointed during that particular period. In other words, if all all their appointed prior to that, during that particular period, which will begin with effect from 10/8/2015.
31/3/2015. The
Another
starting
than
date to change the
31/8/2015. Therefore, 4 years.
4 years, 31/3/19. So they have to complete prior to 1st April 2019. The amendment came into force in the month of July 2017. So there was a period of 18 months.
So the remaining period itself was
Yes,
therefore there is a
right.
period 18 months.
Right.
In which the internship period, training period is also subsumed.
Yes.
6-month period
Yes,
is also.
that
That
was
was
the
the
object.
object.
And the other condition is
Now let's see what they say. Yes, Mr.
Yes,
Yes,
sir. Very much convenient. I also prepared it.
in your own way, I will not come in that. Just I want to know. There is a direction by the apex court to give appointment to the candidates who are similarly circumstanced with the petitioners. Was there such a direction? You have seen that they have read that
No,
direction.
the petitioners were not in government service.
Petitioners were not obviously.
But
If they were in government service, they would not have gone to come here at all.
And you, my learned friend has showed you lordship paragraph 41. That is a one-time dispensation. The Honorable Supreme Court has directed to consider that case. But here,
But clarification review.
the review was filed by some other person.
All right.
Those-
The judgment is applicable.
They apprehended that they will be affected by that judgment.
No.
Yes. Your lordship see the
Anyway, review judgment. Let us understand para 3.
Yes.
Read para 3 of the review judgment.
That will be given effect from 28 from the date of the judgment. And
What it says according to you. That is the juvenile lien of the case.
yes, sir.
Read para 3.
Yes.
Para 2 gives an impression which runs with your assumed stand. But para 3 clarifies the position.
First case. Second. No, no, second. However, to avoid any confusion, we again clarify that the 18
One second. Let us go to the first paragraph. Why people went to the Supreme Court? Candidates went to the Supreme Court.
the grievance sought to be raised on behalf of the review petitioners and some of the applicants before this court is that though they were in employment and covered by the recognition order dated 22/9/2017, they believe that the judgment and order of this court dated 28/11/23 would come in their way if they want to make better their prospects by applying either in other institutions or promotional avenues.
To the same institution, or they want to leave that institution and go to some other institution.
Yes,
Either.
yes,
This is answered. Yeah, they say para 2 is little confusing,
yes.
but para 3 is
However-
just a confusion.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on
2019,
Yes.
17.
and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying
Sorry, for the purpose of
in other institutions
institutions
or for promotional avenues.
use.
Yes.
What is meant by in other institutions?
Other institutions means
Means the institutions wherein they were employed,
yes,
not those institutions. If they want to jump from that institution to another institution,
including government or any other. Yes,
they will be treated as valid candidates.
but here is not the case, man. That's your lordship directed to read a hybrid. But our case is different. Our stand is very different. I have your lordship may kindly see the death chart. I've given just a very glance. Here, our case is they have no cause of action here. They are infiltrators because they were not eligible to apply for the post.
Why they were not?
Yes, that's our case.
How?
Your lordship may see the first 22/8/2023 date. My death chart. Today I have written it on. Statutory guidelines for recruitment of 20,000 numbers of junior teachers schematic that was passed on 22/8/2000 and it's code to the represent the finals. Para 5(1)(I) prescribes qualification category for class 1 to 5, which says
2-year diploma.
yes, class A higher secondary 2 years diploma in elementary education. This is the statutory rule that was introduced by the state government.
Elementary education means what?
Elementary education up to class 8 now. 1 to 8. This was introduced because after the amendment in the RT Act, you lordship must have seen in many cases that they allowed some teachers, in-service teachers in government to complete their OTT exam and so on so within 5 years. So this was the NCT as the academic authority, they have introduced this. As per the RT Act, NCT is the academic authority, not else. My learned friend, which was showing that Minister of Human Resource and Development letter, that has no legal sanctity.
But Supreme Court said it has
And I will also for the Supreme Court, this judgment was passed by the honorable judges of the two division bench, two judgments. But there are three constitutional bench up to even 5 judges bench decisions are there. And that has not been taken into consideration when this judgment was passed.
Once. Then two questions will arise. According to you, the two judgment judgment
Yes.
is per inquiry.
Yes, for inquiry, I have taken this stand.
Can High Court consider the Supreme Court judgment is per inquiry?
Yeah, that I have taken a stand, but your lordship may kindly see. I'll go. Let me place my case. Then your lordship will be passed it. Then on 10/9/23.
But you were a party to that. You were not a party to that judgment.
No. That judgment, Uttarakhand judgment, how it came to the appellate court by law. After the Bihar judgment, Patna High Court judgment, in Sanjay Yadav's case, so Patna High Court held that 18 months is equivalent to that 2 years depot. Accordingly, NCT wrote a letter to all the states and union territories to accept the verdict and accordingly take step. Then Uttarakhand also did the same thing. What happened? Uttarakhand government realized that their statutory rule does not prescribe 18 months diploma qualification. They have in 2012, my not senior was saying, 2012 rule that also prescribes 2 years diploma course. So what they did, the earlier order on 15th January, which was issued allowing those students, that was withdrawn. And this was a challenge before the Uttarakhand High Court. And Uttarakhand High Court then up to the Honorable Appeal Court. Your Lordship may kindly see the judgment my grand senior was showing. Your Lordship may kindly see paragraph 36 of the judgment.
Original judgment.
Yes, the judgment of Apex Court.
That's what new judgment. Paragraph 36.
Yes. All these things are their discussion. Yes.
No, your first contention I just not down. You mean to say this judgment of the Apex Court is per inquiry?
Yeah, I've taken a stand. And I have also 2 judgments, constitutional bench judgment and 1 3-judge judgment I have placed. I've cited. Your Lordship, I'm giving the citation.
Consider.
Yes.
What?
Yes, what? Your Lordship may say, Tej Prakash case.
The Apex Court judgment. Right. Dated?
Dated. 2 judgments are there.
No, not saying this judgment date. 10/12/2024. No. 21/8/2024.
This Uttarakhand judgment.
No, Apex Court judgment.
28/11/23.
28/11/2023
23.
is a per inquiry judgment decision. Since it has not adverted to 2 larger bench decisions of the Apex Court. Which are those decisions?
One is Tej Prakash Pathak and others. 25/2025, 2 Supreme Court cases 1.
And another is?
Another is MB Nair and Union of India and others. 1993, 2 Supreme Court cases 429.
1993, 2 Supreme Court.
2 Supreme Court cases.
That time NCT Act had come into force.
1993.
Whether NCT Act is considered in that bill?
No,
It itself came thereafter.
in 93. NCT Act came in 1993.
Whether that act is considered in that judgment, 29 December 93. That judgment I have seen, which you are now saying, that has never nothing to do with the NCT Act.
Yes. But your Lordship, find the principle decided by the division bench, larger bench. While answering the reference, in Tej Prakash case, paragraph 65, I'm reading this. We therefore answer the reference in the following terms. This is a 5 judgment system. 65.1. The recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rule or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Then other points
How that judgment is relevant?
The state government in 2023, August 2023, introduced the statutory guidelines for recruitment of 20,000 teachers. There, the state government, the educational qualification eligibility condition was prescribed as a 2 years diploma course. Accordingly, on 10/9/23, the advertisement was issued. And thereafter, the petitioners, they know that they are not eligible, they applied for the post. E-admit card NMAS was issued because at that point of time there was no verification. So they attended the CBT test. And some of them, these petitioners, they got qualified and they also qualified and their name were listed in the provisional merit list. Then, in terms of the rule, statutory rule 84, on 16/1/2014, 16/1/2024, the document verification was made. There, it was found that they do not satisfy the eligibility criteria of 2 years diploma. And accordingly, as mentioned in the advertisement, and accordingly, their candidature was rejected, then they have configured it.
Once. Some of them were before the apex court. Yes, sir.
Yes, some writ petitioners, they have filed here, and when the Uttarakhand case was, hearing was going on, they got it. Yes.
Some of the candidates under the very same advertisement were before the apex court. And transfer petitions were, because of that, they were before the apex. The transfer petitions were disposed of, directing you to treat them as having complied with the requirement.
Yes, their petitions were allowed. I don't dispute that.
You don't dispute.
Yes.
If those persons are to be given,
Yes.
why not these people? How can you classify? According to you, even they did not have 2-year diploma.
Yes.
But still the apex court said, give them the appointment orders. This is how the order reads. They are very rare orders. Generally considered for appointment. It's according to the terminology in service judgment. But Supreme Court, after seeing its own judgment, dated 23/11, that you have seen that, and the review judgment,
Yes.
apex court said, give them appointment. Order is so specific. They did not have 2-year diploma.
So they don't. But
I want to know.
yes.
So you want to say, those who have brought orders from the apex court, to them we will admit to the recruitment process. Those who did not bring the orders, we exclude them because they don't comply with the advertisement.
No. That is not right. Our stand is that Honorable Supreme Court has, as a one-time dispensation, that the order passed. Yes. Yes, sir. Your Lordship is right.
No, under the very same advertisement, you admit, under the very same advertisement, identical candidates obtain the orders of the apex court at the hands of the
Being transferred from this court.
You the party.
Yes, from being transferred from this.
Yes. You should have said, your judgment is
Yes.
very young, therefore do not pass these orders.
Yes, sir. We have not said.
You have not done that. And now still you want to oppose the petition, saying that for one set of people that they comply with the requirement because they have obtained the orders of the apex court. The other set of people, they are before this court, they have not obtained the orders of the apex court. Therefore, we deny the relief to them. How? They got a relief. You were a party to that proceeding before the apex court. Because those cases were withdrawn by the apex court to its portal from our court.
Yes. That is the
Therefore, you were a party. And you suffered order there. And here you want to oppose.
It is admitted that we have not raised this issue.
Then how many of such people were there before the apex court? 19 people. For 19 people, you are giving appointment orders, and to these people, you don't want to give appointment orders.
No. Here now, 25, 22, 20.
So they are 200. I am just asking you. If you have suffered an order at the hands of the apex court, should you not extend the same benefit to the rest of the people, whether they are here or not? Everybody should come to court. That is the reason why pendency happens.
So they have by an amendment. After they have by an amendment they brought to your Lordship's notice. Initially in the repetition they have not pleaded. Yes, by an amendment they brought.
Petition only there. During the pendency of the writ application, the review petition was allowed.
Yes.
Subsequently, the DRP was
Yes.
allowed. That is why we have brought on record by way of amendment.
That I'm saying.
So you did not tell the apex court in all those matters. No, your judgment is per inferium. Therefore, do not pass these orders. You agreed with the interpretation with the apex court list. And you suffered the order. Orders have attained finality. You are not filed review. On those orders, you are not filed review.
No review.
Nor have you filed review on the main judgment because you are not a party.
Yes.
Then what will be opposite petition? So you want to create two sets of people. One, those who obtain the orders of the court and therefore they are entitled to. Others, those who are similarly circumstanced but they have not brought the apex court order but they are here before this court, then to them we will not give. That only Mohammed bin Parla can say. Not the welfare government. Rightly or wrongly. Apex court say. Review it clarified. To remove the doubt, confusion. See that how the wording of the apex court judgment. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons, those who were appointed prior to that cutoff during that 4-year period, we have completed 18 months diploma. If that is there, once a diploma obtained by such persons who were in employment as on 10/8/2017, and we have completed the diploma course of 18 months, to be treated as valid diploma holders for the purpose of applying in other institutions or for promotional learning that will not arise here. And pursuant to this, other orders are made. 19% have secured the order. You want to give, you have to, unless you say, we will not abide by the Supreme Court order.
No,
that you may not say, perhaps.
Your Lordship may pass.
Please give the dates. Just clarify me.
Date charter. Date charter. Date charter. Date charter.
Return of witness of the pleadings and the documents accompanying the same. The short question that calls for consideration of this code in these petitions having common fact matrix can be stated as written. Whether the candidates who were in employment as on 10/8/2017, can you be seated? I'm getting confused with your standing. And who have completed the diploma course of 18 months in the light of NCTE recognition order dated. Sit down and answer.
22/9/17.
22/9/2017. Or to be treated as having 2-year diploma specified in the recruitment advertisement dated. That is
10/9/23.
10/9/2023. Question mark. Next paragraph. Learned senior advocates appearing for the petitioners, drawing attention of the court to paragraphs 4.7, 4.10, 23, 25, 28, 29, 35, and 41 of the apex court judgment dated
28/11/23.
28/11,
2023.
2023. Submit that. The answer to the above question has to be in the affirmative. Question. They adumbrate their submission by placing reliance on paragraphs 1 and 3 of the apex court review order of the said judgment. Question. Next paragraph. Learned AGA appearing for the office in his usual vehemence opposes the petition, contending that the answer to the above question has to be in the negative, in as much as the apex court judgment is peremptorium, since it did not consider other larger bench judgments. Simple. It has been a settled position of service jurisprudence that what is prescribed in the advertisement as qualification has to be strictly complied with. More particularly when such a qualification is prescribed in terms of what has been prescribed by the NCTE, a statutory body under NCTE Act 1993. Having heard the reflection appearing for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter for the following reasons. 1. Shorn of details, the apex court judgment dated 28/11/2023 makes it abundantly clear that the candidates who were in employment as on 10/8/2017 and have completed the diploma course of 18 months in terms of NCTE recognition order would be treated as having the requisite diploma of 2 years. This becomes abundantly clear by the observations of the apex court in paragraphs 1 and 3 of the review judgment, which read as under. Next one. To the pointed question, learned AGA Mr. Lenka very fairly conceded that some of the candidates who were in the fray pursuant to the very same recruitment process were before this court, and their transfer petitions filed in the apex court having been allowed, they were directed to be given appointment to the post in question on the ground that their 18-month diploma approximates to 2-year diploma prescribed in the advertisement. First, it is very pertinent to notice the terminology of the apex code orders in respect of 19 such candidates, wherein the direction is not to consider for not only not to consider for appointment, but to issue appointment orders. First, it is not much in dispute that these petitioners are absolutely similarly circumstanced for those 19 persons who had knocked at the doors of apex code of the country and secured orders favorable to them. First, if contention of Mr. Lenka were to be countenanced and the leave is to be denied to the petitioner's hearing, that would foul of Article 14 of the Constitution of India. In as much as this court would be creating a class within the class, there being absolutely no differential, nor the object for to be achieved by arguable differential. First, in the above circumstances, these petitions succeed. A writ of certiorari issues flashing with said paragraph. Reject list dated 5/8/24. Paragraph. Reject is Addition 14 version. That paragraph is version. That is Annexure 7, page 42. Relevant page is page 44. Clause number 5. Flashing clause 5, which is entitled candidates of the petitioner's time who were having 18 months DEIED course. DEIED. Diploma in Elementary Education. Diploma in Elementary Education. Is flashed. Petitioners, such of the petitioners who were in employment as on 10/8/2017, and we have done 18 months diploma course into present. 6 months training having been subsumed within the company shall be treated as satisfying the requirement of 2-year diploma prescribed in the advertise. Sorry, a writ of mandamus issues to whom?
Poster teacher. Already, I mean, बच्चों की entry model poster पे teacher.
And copy numbers?
Copy number 1 and 2. Two poster numbers. So much.
Who issues the appointment? There cannot be two. One has to issue.
One.
Copy number one. You mentioned state government. Yes, state government. To issue appointment orders to the petitioners if they are otherwise eligible and qualified. Just mention one more point. It is relevant to mention that this court, by the interim orders, had reserved the vacancies so that if the petitioners succeed, they could be accommodated. Therefore, there is no hardship or objection, sustainable objection, as to why the petitioner should be denied the relief, which the apex court itself has granted to rest of the candidates, namely the 19 months persons who were before him. Within what period appointment orders would be issued? And if not issued, what should happen? Again, we don't want cases here. Mr. Lenka, within what period you will issue the appointment orders?
Lakshmi give 3 months.
3 months.
Yes.
Are you bringing appointment order papers from Switzerland?
No. That
3 months. Different from the date when you are giving the appointment to rest of the people pursuant to apex court
No,
order.
already they have been recruited.
They have been recruited.
The advertisement was for 20,000.
Within 6 months. Within 6 weeks.
6 weeks. 3 months.
I report compliance to the Registrar General of this court, telling which it is open to the petitioner to move an appropriate application for taking penal action against the officials for non-compliance. The penal action may include levy of very heavy costs and imprisonment also.
Your Lordship, may I wonder? Your Lordship's order was to confine to the petitioners.
No, I will not confine them.
Because
You want other people to come here?
may come.
Why? They should not. Apex court say, which is a judgment, similar to relief should be granted to. Others should not be given to court at all. Court is not a happy thing. Apex court knows that.
There must be a
Ah.
post must be there.
Well, we do not want that. It's whatever you want to.
All cases.
Otherwise, see, we don't want any contempt petitions. I have made it very clear. Matters will come to Apex court, and I will implement the order.
Your lordship's order,
Contempt.
your lordship's order will be complied within 3 months. That
Challenge is
that. No, that is because I am apprehending that after your lordship's judgment.
No, 1 second. The judgments of the court are meant for implementation. They are not for court of fame. If implementation does not, you have argued, we have considered your contentions. Very vociferously argued. We have considered. Rightly or wrongly, we have handed an order. I have handed an order. As long as that order remains, it should be complied.
It will be complied. That-
Otherwise,
Yes.
I have said what will happen. That
No,
is
that-
warning because this warning is given since this court has been observing day in and day out non-compliance of these orders, resulting into filing of billboard of contempt petitions and the like.
All the rest of all the cases,
Except the last one.
Last one,
That is only for reference. That is respect to 19 persons. You also added for reference purpose. The last one, the T number.
Where is that order of the apex court? Just give that order. Where the directed appointment. Separately, you give that. See, judgment of the apex court I need. Review judgment I need. Your advertisement copy I need. Then recognition order of the NCT I need. Okay. And orders of the apex court where appointment is to be given. You separately. Okay. This will be the broad parameter of parameters of these will be parameters of my judgment. Little linguistic change. This is very grateful.
Authorizing a gift to the court person.